नमस्कार। सुप्रीम कोर्ट में आज शिवसेना विवाद पर एक बार फिर बेहद ऐतिहासिक और तीखी बहस देखने को मिली। उद्धव ठाकरे गुट की ओर से देश के दिग्गज कानूनी विशेषज्ञ वरिष्ठ अधिवक्ता कपिल सिब्बल ने अदालत के सामने कई ऐसे संवैधानिक सवाल खड़े किए जिसने देश के सियासी और कानूनी गलियारों में हलचल तेज कर दी है। आइए बेहद आसान शब्दों में आज की इस महत्वपूर्ण अदालती कार्रवाई को समझते हैं। कपिल सिब्बल ने आज सीधे चुनाव आयोग के फैसले की कानूनी वैधता पर प्रहार किया। उन्होंने अदालत से कहा कि सिर्फ विधायकों और सांसदों के संख्या बल के आधार पर किसी मूल राजनीतिक दल का मालिकाना हक तय नहीं किया जा सकता। सिब्बल का तर्क था कि विधायी दल में फूट पड़ने का मतलब यह कतई नहीं है कि मूल संगठन या राजनीतिक पार्टी का वजूद ही खत्म हो गया हो। इतना ही नहीं, सिब्बल ने शिवसेना के मूल संविधान का हवाला देते हुए शिंदे गुट के मुख्य नेता पद पर भी सवाल उठाए। उन्होंने दलील दी कि चुनाव आयोग को किसी राजनीतिक दल के आंतरिक संविधान की लोकतांत्रिक समीक्षा करने का कानूनी अधिकार क्षेत्र ही नहीं है और इसे एक पूर्व नियोजित दल बदल करार दिया। अदालत ने भी माना कि विधायी दल पर हमेशा मूल राजनीतिक दल का ही नियंत्रण होता है। इस बड़े मामले की सुनवाई अब अगले हफ्ते भी जारी रहेगी। यह वीडियो केवल शैक्षणिक और सूचनात्मक उद्देश्यों के लिए है। इसका उद्देश्य किसी भी कानूनी मामले पर टिप्पणी करना या न्यायालय की अवमानना करना नहीं है, बल्कि केवल अदालत में पेश किए गए तर्कों को निष्पक्ष रूप से प्रस्तुत करना है।
Whereas yesterday was showing to your lordships 29A subsection right through to 4 to 9. Now, just if your lordships be kind enough to go back to 29A subsection 9 in the context of subsection 4. It's part of the statutes, Mullahs. Compilation of statutes. Page 9 and 10, Mullahs. Now, if your lordship looks at 9, because I just want to go back to 2-3 documents, Mullahs. Says page 8 and 9, Mullahs. 9 and 10, Mullahs. 124, 129, 29A.
29A.
Subsection 9.
What is the page number, Mr.?
Page is 9. Compilation of statutes, page 10, Mullahs, probably.
Subsection 9 is at page.
Subsection 9 is at 10, Mullahs.
Yes, 29A.
Yes. Now it says, Mullahs, at 10, after an association or body has been registered. So we were registered long ago, right at the top of the page. As a political party, as aforesaid, any change in its name, head office, office bearers, address, or any other material particulars which my Lord Justice Bajki mentioned, shall be communicated to the Commission without delay. Now, Mullahs, this relates back to 4. Change in its name, your Lordship notices. Head office, where the head office is, that is B. Then, Mullahs, office bearers, that is D. And address. So, Mullahs, if there's any change in that, Mullahs, that's all that has to be communicated. We don't know what other particulars are, nor has been specified by the Commission or under the statute. Right, Mullahs? Now, kindly see in that context, Mullahs, what we had communicated to them. Because there's unnecessary controversy on that. And you go back, Mullahs, to the document, which is 20, in the compilation of documents, convenience compilation. The 27th February document.
That's at page 20.
Page 21 of the
Convenience.
convenience compilation. PDF 29, page 21.
27th February.
That's correct. That's nominal. Because I've read subsection 9 and 4 to your lordships. So, Mullahs, what was my duty? I say on 27th February, your letter of 25th of January. So I'm writing to the Commission pursuant to their own letter. And I say organizational elections of Shiv Sena have been conducted on 23rd of January at Mumbai, and the information regarding the designations and names of the party office bearers sought by your office Election Commission of India is being enclosed herewith in format for your record. So much they know, they already know there has been a change, so they say, please tell us. Now kindly see what we, page 26. What is the information we give?
Information is 22, na?
Information is 22, Malas. No, yes, just why are you giving me the wrong? I'm talking about 20, why is it 26? Please. 22, Malas. Now says, we say designation of delegates who attended and participated in the election process. So they are fully aware that there is an election process going on. And Malas, Shiv Sena Paksh Pramukh. Now they have the 1999 constitution. They say they know nothing about any Paksh Pramukh. So Malas, they know that the 1999 constitution had no Paksh Pramukh. So it's in 2026 that they realized. So we tell them Paksh Pramukh, the president, Shiv Sena leaders, deputy leaders, secretaries, MPs, MLAs, Sampark Pramukh and Zilla Pramukh and Vibhag Pramukh. Name of office bearers elected, Uddhav Thackeray, Aditya Uddhav Thackeray, Manoj Joshi, Sudhir Joshi, etc. List of names of leaders and deputy leaders. Consistent with 29A9, Maras?
No,
That's all.
this information is not 29A9. Because 9 you will inform. 9 you are, in fact, 9 you are not required to inform unless you can put it. Any change.
This is the change, Maras.
Change in the, so this is only a change in the office bearer.
That's why this one. Therefore, it's within 9. What I'm saying is, Maras, whatever was required under the statute, we did. There is no issue of the constitution here. Nor is it a statutory requirement. Though we gave it, Maharaj, it's our case. What we do is, Maharaj, let me tell you what the practice was. We used to send this letter. Appended with that was the latest amendments of the Constitution. They used to take that away, Maharaj, because the Constitution will not be put up in the site again. So they would put only these documents on the site. And the rest they would keep. Now it's very convenient to say, I don't have the Constitution. So, Maharaj, we point this out. And then, Maharaj, we set out the National Executive meet on 23rd of January. That's at page, Maharaj, 23. And we say, Maharaj, these are the elected office bearers,
Deputy leaders.
elected deputy leaders, Shiv Sena deputy leaders, and these are the elected people. Again, the election commission says that all deputy leaders are nominated. Well, let's kindly see what is happening here. They don't even look at their own document, which we have supplied to them. In the finding of the election commission, he says these are all nominated. Then annexure 2. Now, this is a very interesting verse. We point out who are appointed by us. That is the Paksh Pramukh. And your lordships will find item 4, Eknath Shinde. And then Shiv Sena Paksh Pramukh Uddhavji appointing the following members as deputy leaders. So, Maharaj, the deputy leaders were in all about 31 in number, 33 in number, 12 were nominated, 21 were elected. This we also mentioned, Maharaj. And according to us, under that as annexure 5, we put the. Now, this is letter of 27th of February. Now, Maharaj, the next document, and it's very interesting, Maharaj, the next document they completely deny. They say we haven't received this document. Page 26.
Page 20.
26, Maharaj. Now, Maharaj, your lordships will note here the date 4th of April and the stamp of the commission. This is in 2018. The previous document that I showed to your lordships,
That was February 2018.
that is February 2018. This is April 2018, right, Mullah? And that, according to us, Mullah, now, on the left-hand side, you'll see see Mullah in brackets written DEC CBR. Also, you see that?
Yes, yes.
Now, the DEC CBR is Deputy Election Commissioner, Deputy Election Commissioner, and CBR stands for Coordination, By-Election and Rules. So it is directly given to the Deputy Election Commissioner. That's, and when in 2018, I couldn't be forging a document. For what was I forging a document? And that's not even their case. Now, what they say is, if you look at what is their case, Mullah, kindly go back to page 18. They say that in the other document, there is a receipt with a signature, and on the side, there are obviously of diary numbers and officers of at different levels. They say it doesn't exist here. If you compare it with 18. And probably because it's handed over directly to the Deputy Election Commissioner. But be that as it may, Mullah, according to us, when on the 4th of April, we again pointed this out. But the more important thing, Mullah, is the document.
Only thing is the number of leaders have changed.
Yes.
In February, the number of leaders Shiv Sena
This-
Pramukh appoints
It's the same, Mullah.
4, whereas in page 27, it is
Elected.
It's the elected ones, Mullah.
6, 7, 8, and
That's
9
27 are the elected ones. The others are the nominated ones.
appointed.
Yes, appointed ones.
27 corresponds to 22.
27 corresponds to 22, Mullah.
Column 4.
Column 4.
Name of office bearer.
Name of office bearers elected. Your Lordship sees that on top? Name of office bearers elected.
9 leaders.
And there are 9 leaders there.
Elected office.
Yes.
Column
So these are nominated office.
No, these are elected. It says elected.
I'm saying 27
27 is
February. You are
27th February is elected, Mullah.
same names. Page 24.
Page 27, Mullah.
Page 24.
24, okay, I just count.
page 24 are nominated.
Those are nominated.
Page 24.
Of course, they are nominated. It says so, Mullah.
In the 27th February letter,
Yes,
you don't inform the elected members' name.
we do, we do.
That's at page 23.
That's at page 23, Mullah.
22.
And 22. We inform both, Mullah. Nobody's case that we didn't inform.
22.
This debtor is accepted, Mullah.
22 पे column.
Kindly see page 22, column 4.
So this is
That is the name of office bearers elected.
Yes.
Lordship,
Yes,
is that?
deputy leaders.
No, no, no. Page 22, Mullah. Page 22,
Yes.
column 4.
column 4.
These are the leaders under the Pakshram.
Under the Paksh Pramukh, Mullah, they've
So what is the difference between page number 23 and 24 names? Some are mentioned as deputy leaders. And in 24, you say that
I mean, these are-
4 are leaders and rest are not deputy.
23 is elected.
Same day, there are 2.
Yes, 23 is elected. The others are Mullahs appointed.
Sir, comment some of.
No. You see Mullahs National Executive meet of 23rd January, Shiv Sena deputy leaders elected.
No way for
It's all there, Mullahs.
Same information.
Kritikar, Aditya Thackeray to Kritikar, a 9 at page 22 and 27. Okay.
This is another.
That is the one.
Yes.
That's
Yes, it's all there.
9
Mullah.
leaders.
It's all clear, Mullah. So we inform in terms of 29A9, we inform them as to what changes have taken place. We're not required to inform anything else. It's our case, we also gave the constitution under which it was amended.
There is a reference to the constitution.
There is also,
4th April letter.
correct, but
which
they don't
will
accept.
Claim that it has, their claim is that this document is created later on, it was never communicated.
Malas, he said they won't take it on record. Malas, how could it be created in 2018? What benefit would I going to get?
No, it was created later on this.
If it's later on, then I should be prosecuted.
No, that.
There is a stamp. Malas, there's a stamp of the Election Commission. Anyway, let's not get into that. Malas. We need not go.
The more fundamental argument is 28(9) does not require you to communicate an amendment to the constitution.
That's right.
It requires you to communicate particulars which have changed in relation to the items in subsection 4 of it.
Correct. And Malas, that is because
That does not include an amendment to the constitution.
that's correct. And had they asked me, and
You would have got.
I would have definitely forwarded it. So, Malas, I just wanted to say that what we did was consistent with the statute itself. Now, let's come back to paragraph 83, Malas, of the order of the Election Commission, where I stopped yesterday.
496.
Page 496 of the convenience compilation.
Easier.
Yes. Para 83 at 504 PDF and otherwise 496. 496. And he says, para 83, the commission by letter dated 2018 sought information from all recognized political parties. That's why that said that we have received your letter and therefore we are forwarding this. To confirm the outcome of inter-party elections by 28/2/2018, by letter dated 27/2, Anil Desai informed the commission of the names of office bearers of Shiv Sena after the completion of the organizational elections, obfuscating the fact of changes made in the party constitution. So this is his own spin on it, under which the organizational elections and the appointment of office bearers was made. The information of change in the party constitution was not linked to such changes in the office bearers. It is clear that the constitution being cited to by both groups as amended in 2018 was not categorically taken on record. What does that mean, Malas? That it was not categorically taken on record. The petitioner also, although silent from 2018 till the present proceedings, disputes the amendment, though being in his specific knowledge, now and argues against its arbitrary design and its non-democratic character. That's of course Shinde's group. The respondent cites the same document, thereby attempting to displace the agreed constitution of 1999 surreptitiously, being without a confirmation or scrutiny of the amendment process itself having been followed diligently. But what's the relevance of this? Para 15, Malas, says that there should be a split in the party. What's the relevance of all this inquiry? And he ultimately comes to the conclusion, the split in the legislature amounts to split in the party. But Malas, that's not even para 15. So the entire substratum of the judgment is completely contrary to the exercise under paragraph 15. As well as the Chief Justice Chandrachud then in the Constitution bench said, para 15 doesn't even talk about the legislative party. It's not even concerned with it. It's concerned with it in the context of who enjoys the majority, provided there is a split. Then that question will arise. Then, Malas, the commission has, I'm sorry, paragraph 84, Malas. The commission has applied the test of party constitution in its primary manifestation to allow the commission to distinguish between frivolous disputes and avoidance of subterfuge. In fact, it can be viewed as an extension of maintainability. And the preceding paragraphs above clearly show that the fact of the dispute not being non-serious is not made out. I know what that means. In the next manifestation of the test of party constitution is the issue of the design of the constitution. Whether the group or faction which has approached the commission has exhausted the internal remedy or due to an impasse, it has approached the commission under paragraph 15. The logic is, may I tell your lordships, he says, under your constitution, there is an internal remedy, means you can send a notice to him and expel him. But Manas, the person has already gone to Surat and he's gone to Guwahati. He is the CM. He has already, Manas. What am I to expel him for? He has expelled me. Like, the exhaustion of internal remedy was itself premised on two independent aspects. The group which approaches the Constitution has to show that it has exhausted all the remedies available to it under the Constitution of the party to assert its majority, but that the other group has frustrated its efforts whimsically or capriciously and is not itself functioning in accordance with the provisions of the Constitution of the party or democratic norms. The Constitution being referred to and submitted in the pleadings by way of its plain reading on the vital axis of remedy, modality of dissent in such factual circumstances stifles all options of rival group in its very formulation. How is this relevant at all? Then he says further, Rule 2 provides for a disciplinary action committee. We did not go into all this. He says there's a disciplinary action committee, you should have gone there. Further, the 2018 amendment of the party constitution has made the position of Shiv Sena Paksh Pramukh a power center. And as per Article 11 of the said constitution, now he's referring to the 2018 constitution. The extensive power and functions of Shiv Sena Paksh Pramukh are as follows. Then he sets those out. Right? For the moment, skip it, Maras. Let's go back to the party structure. Let's show that to my lords. So that I explain to your lordships to what extent it's democratic and undemocratic. Huh? Yeah, from the party constitution.
This same volume,
Same volume, Maras.
page 56. Page 56, PDF 64.
Page 56. Shiv Sena Constitution. That's the 2018. Yeah, 1 second. I'm only responding to my Lord Justice Bagchi's query that you show us on facts. So I'm showing on facts, Malas. So page 57, first, Article 4, consistent with 29(5), 29A5, that I owe allegiance to the Constitution, right? Believes in party democracy, ideology, and all that, Malas. And then come to Article 8, organizational structure. Now, your lordships will notice here, organization structure, Schedule A by election. Who are the leaders appointed by election, Malas? The Paksh Pramukh. He's appointed by election, Malas.
Which page are you reading?
Page 59. He is appointed by election. Rashtriya Karkarni by election, which is the highest national executive, which consists of 13 people, Malas, as a matter of fact, at that point in time, of which 9 are elected and 4 were appointed. And then the deputy leaders, 31, 33 in number, 21 elected, 12 appointed. So, what is the highest policy-making body of Shiv Sena is entirely democratic.
And the appointed leaders and deputy leaders have to get elected in the next election.
I'll come to that later. It's part of the constitution. I'll come to that later. Now, Millards, who are the ones who are scheduled by appointment, scheduled B by appointment? Shiv Sena leader. So, Millards, Eknath Shinde was appointed as Shiv Sena leader under this constitution. Deputy leader means the deputy leaders are elected also and appointed also. Then then the secretary, Millards, the two secretaries. Why should secretaries of the organization be elected? Millards, is a treasurer of a party elected? No. Zila Sampark Pramukh. Why should he be elected? Zila Pramukh. Up Zila Pramukh.
They are all nominated.
They're all nominated. Reason being simple, Millards. These are people who exercise powers for implementation of the policy decisions taken by the elected body. So that means every DCC president who has nominated people in the DCC, that is the election, must be elected.
But this expression Shiv Sena leader appears to be a little vague. Shiv Sena leader means leader in legislative assembly or in party or
No, party, Millards, party. That will show later. It's part of it, Millards. You're also fine. The point is, Millards, who is the election commission to now determine as to at which level, how many people, and on which post, who is going to be elected? And Millards, your lordships may realize there is no dispute pending with the election commission on any of this. Election commission is deciding a para 15 dispute. There is no dispute in the election commission any of the provisions of this constitution or the elections or nominations made. There is no complaint of any authoritative exercise of power. None of it. And the commission says that this is an autocratic constitution. I mean, it's because the commission wants to come to a particular conclusion, and it's no way to come to that conclusion unless you exclude the constitution, exclude the organization, and then say, I'm left with the legislative party and they have a majority, and therefore I'll give them the symbol. So you predetermine your end, and then you manipulate the logic for it, contrary to the very exercise in the paragraph 15. Now, let's kindly see, and for the cities, Shahar Pramukh, Vibhag Pramukh, so they should also be elected. Then, administrative structure. This is also by appointment. The others by appointment is to implement the policies of the party. This is the administrative structure, namely the general secretary, the treasurer, and the secretary. Koshadhyaksh, Sachiv, and Sachitnis. And then the similar for the states. Then, Millards, Article 8. These are the members of the Pratinidhi Sabha. This is the other apex body. You have the Paksh Pramukh, you have the Pratinidhi Sabha, Rashtriya Karkarni, and the Pratinidhi Sabha. Now, Millards, the Pratinidhi Sabha will have all these deputy leaders who are nominated, secretaries who are nominated, elected members, Zila Samparks who are nominated, Zila Pramukh nominated, Vibhag nominated. So the logic is that since the body, that is the Pratinidhi Sabha, which elects the leader and the Karyakarani, right? I have a majority of nominated people. This constitution is undemocratic. Logic. How can this exercise be done by the commission? Is the commission now going to, in a para 15 dispute, go into this? But forget that, Malaj. Under which law is the commission entitled to say that these posts, these persons who you nominate or these persons who are functioning for you must be elected? That's why I mentioned 19(1)(c), Malaj. It's only in that context. What is the constitutional morality? It's a voluntary organization. It's a political organization. You don't want to be part of it, don't be part of it. But you can't manipulate and regulate my structure at the level of running a political system, competing with other political parties to make sure that I win the next election. And whereas if you embroil yourself in these things, there'll be no time for election hearing, Malaj, because the whole exercise will be spent on multiple elections at every level. So I'm saying, Malaj, I'm sorry to say this is outside the jurisdiction of the commission. Completely. Even otherwise, forgetting about 29A. A party, a voluntary organization must be allowed to run in the manner it wishes to run. Now, Malaj, the office bearers of the Rashtriya Karyakarani is at page 63, Article 10. The term Shiv Sena Pramukh shall never be bestowed upon any office bearer of the party, and therefore the designation Shiv Sena Pramukh stands frozen forever. Whereas I just pause here, whereas everybody knew, including the election commission, that Bal Thackeray was no more. And they read the letter that I sent to them that I am the Paksh Pramukh. So surely they know that there is another constitution. They knew about it once I sent them the letter in 2013. Why did the election commission wait till 2026 to find out whether there's another constitution or not? Only when the dispute arose? In the final hearing, in the final hearing of the matter. For 13 years, they waited. This is the Election Commission of India, which is overseeing elections, the formation, the office bearers of every political party in this country, and especially Shiv Sena was a recognized political party. And they don't know for 13 years that there's a change in the constitution, and they choose never to write a letter to us. And then they take the specious plea that, this constitution is not on the record of this commission. Anyway, it shall never be bestowed with the blessings of Hindu Hriday Samrat, Shiv Sena Pramukh, late Shri Balasaheb Thackeray, the office bearer of the Rashtriya Karyakarani, as follows. Shiv Sena Paksh Pramukh shall be the president of the party and shall be elected by the members of the Pratinidhi Sabha. Roship sees that? That Pratinidhi Sabha, where they say majority are nominated. So he's elected by them. From amongst its members of the Rashtriya Karyakarani. Then such chiefness of the party is the chief office bearer in the administrative structure of the party, who is appointed by the Shiv Sena Pramukh, Paksh Pramukh. And Koshadhyaksha is the office bearer, and Sachiv is the office bearer. They're all appointed by the Paksh Pramukh. Then there is Rashtriya Karyakarani. Paksh Pramukh is the chairman of the Rashtriya Karyakarani. Shiv Sena Pramukh shall be the president of the party and shall be elected by the members of the Pratinidhi Sabha from amongst the members of the Rashtriya Karyakarani. The term Shiv Sena Paksh Pramukh shall be for a period of 5 years. Shiv Sena Paksh Pramukh shall be of the highest authority in the party, and his decisions in all matters concerning the party policy. Now, this is important. And party administration shall be final. Shiv Sena Paksh Pramukh can withhold, remove, or annul the appointment of any post mentioned in Article 8. Shiv Sena Paksh Pramukh shall have the right to dissolve the Rashtriya Karyakarani at any time. Shiv Sena Paksh Pramukh may, at his discretion, co-opt members as Shiv Sena leaders, deputy leaders of the party, Now, this is important. The member so appointed as the Shiv Sena leader or deputy leader, as the case may be, shall assume the office of Shiv Sena leader or deputy leader and work under the guidance and direction of the Shiv Sena Paksh Pramukh. However, members so appointed by Shiv Sena Paksh Pramukh as a Shiv Sena leader shall follow the process of filling his or her nominations in the next intra-party elections and get himself herself elected by the Pratinidhi Sabha to be a member of the Rashtriya Karyanayami. So if I nominate you, you will have to get elected. Similarly, a deputy leader appointed by Shiv Sena Paksh Pramukh shall follow the process of filling his or her nominations to the next inter-party elections and get himself herself elected by the Pratinidhi Sabha. So even though I appoint them now, you'll have to get elected.
This part you can skip just the Sibal. We don't think that it will have any bearing, much bearing.
I might say, but Manoj, that's what the Election Commission has done.
No, page 64 is well summed up everything.
60,
Page 64.
Yes.
The entire structure of the party.
yes,
It has been well summed up here.
yes.
For our purposes, it is good enough.
It is?
It is good enough for us to understand the
Yeah, very good.
structure of the party.
Very good.
That you have given at page 64.
That's correct. So, all I'm trying to say is there is nothing before the commission to come to a conclusion without any facts, without any notice. No, this is an autocratic structure, therefore I will not look at the constitution.
It's legislative.
I also think, Manoj, but since my lord asked me that, I must point out, Manoj, what the factual situation is. Very well. Then, Manoj, I'll skip this. Then go back, Manoj, to, I just want to show one thing, Manoj, if you also don't mind, page 67. Just only one fact, and then I'll go to para 84, Manoj. Deputy leader, the total number of deputy leaders shall be 33, just to show your lordship that what I said was correct. Shiv Sena Paksh Pramukh may at his absolute discretion co-opt members as Shiv Sena deputy leaders, that's the 11 in number. Members who are appointed as they shall assume the office of deputy and will perform the duty. Leave that out, Manoj. So, Manoj, I'll skip all. Yes, the function, kindly see the function of the Pratinidhi Sabha at the bottom, Manoj, of page 67, and then I've done with this
That
document.
you can refer to show that there is an election process
Yes,
to elect your Shiv Sena Paksh Pramukh.
yes. And
Rashtriya
Rashtriya Karyanayami and the deputy leaders. Serial number 2.
Commission says all are appointed.
And the commission says all are appointed. But anyway, Manoj, we're not. Now come back, Manoj, to
Page 504, 496,
50. Yes.
496.
So I was, Manoj, at page, paragraph 85. Where, no, and he talks about the design of the constitution. Well, in fact, I read para 85, come to 2000, para 87. No, para 87 I was reading and I said, I'll show you the constitution.
497,
490.
Like this, he's going to be able to he read 87.
Actually, we just started.
Yes.
Now, Manoj, bottom of page 498, the rest of Manoj I've skipped because I've already shown you the party constitution. The bottom of page 498.
Order of the Election Commission.
Yes, in view of the aforesaid powers entrusted upon the Shiv Sena Paks Pramukh by the 2018 amendment, there cannot be any other inference but that the party president has been vested with authoritarian powers. This consequently compromises on the norms of intra-party democracy and perpetuates fiefdom on an individual of the rights of innumerable party workers. No complaint by anybody. Anyway, then Maharaj, he relies upon this Samajwadi Party judgment, which is at the next. He says it is also pertinent to mention that in the Samajwadi Party dispute, also a contention was made on behalf of the respondent therein, the primacy to be given to test of party constitution by adjudicating the dispute. In the said case, also one of the crucial factors indicating the emergence of rival groups was a convention called by the claimant therein, which was alleged to be unconstitutional by the other faction. Whereas Mulayam Singh's faction said that the convention that has been called by Akhilesh Yadav was unconstitutional. But that's not relevant because it was a dispute relating to who represents the party. It related to the split of the party, and that's the decision that the Election Commission came to.
What happened in that dispute? Son won or the father?
No, but the son won. I was for the son in that matter. So we got the cycle on which the Congress party rode at the back.
Party only, it was the family also divided.
What happened was, the Congress party sat at the back and lost,
Party became the property and family stood divided in family.
That's correct. But Mullah, as I was going down the commission, that's on a personal level. Mulayam Singh was a great friend of mine, was with me in the elevator. So I had been arguing for the son. So he looked at me, he said, "Haan, theek hai."
But probably they amicably settled before he died,
Yes, it was all settled. It was all settled.
if I remember correctly.
Yes, because the party all shifted to Akhilesh, so it was all settled. And he was quite happy then.
These are, as the commission has commented, whether we see it as a picture,
Yes,
timestamp picture
yeah.
of majority control,
Yeah.
or an evolving majority control.
Yeah.
So what happens is right-wrong decision. The evolving majority control will shift.
Absolutely, without any doubt. That's I said about the magnet the other day, Mullah. Those who are not with us will shift because they see the power structure, and that's a magnet.
That you also need to address while we decide this issue.
Of course.
As to subsequent events, do we take into consideration subsequent?
But that will not arise in this case for the simple reason that the split has to be decided on the day, on the...
Split is one question. Again,
Yes,
two issues are different.
sure.
The symbol is a different thing. That relates to the party.
Yes,
Split has to be decided under the tension.
correct. No. I'm talking about paragraph 15.
Split in the parliamentary.
Yeah. I'm not on that. I'm on paragraph.
The legislative party and split in the party.
So, but if paragraph 15 doesn't talk of, then the rest doesn't arise.
It has become
That's it.
irrelevant.
So that's my fundamental point.
But your affidavits show that there was a substantial backing of the rival group in the organization and primary membership.
Not in the organization, but that's also afterwards. Please.
That is where we are putting this question.
Yeah.
This afterward fact, whether it can be taken in.
Then take it then. Even then, I'm far ahead.
Primary membership of 4 lakh Shiv Sainiks are with the rival.
We had 19 lakhs.
We are not on that question. Now you are jumping ship. First, we see whether there is a split, right? The split can originate in the legislative party, but its crack can percolate into the organization.
Well, let me-
primary membership.
Well, let me answer that. No, but the split can never arise in the legislative party as a party split, as a proposition of law. Can never arise. That's been decided by the Constitution bench for us.
The Constitution bench says that the test of a split cannot be restricted to a split in the legislative party. But it never says that a split in the legislative party, if it gets reflected in the organization and the primary membership, it needs to be.
No, I'm sorry, Manas.
Because
I'm sorry.
it is like the epicenter of a
But
earthquake.
forget about what the Constitution bench says. Read para 15. Manas, just look at para 15.
Para 15
Doesn't talk about legislature.
That logic we have to take into consideration after hearing the respondents here. But we have followed your submission in, it appears to require further scrutiny. It is logic. You're making a strong case.
No, that's all right, Manas.
Making a strong case.
I'm only saying,
But
saying.
what we are seeing is, Mr. Sibal, if we trouble you.
Yes, please.
List of dates.
Yes.
You see, in your list of dates, you have yourself said that affidavits were filed.
Yes, of course.
Affidavits show
Of course.
it's not that Mr. Shinde Group.
And, I showed it myself to your lordship the other day. Manas.
So we wanted clarity there.
Yes, certainly.
So when Raj Prabharis,
Yeah.
he has 11 Raj Prabharis,
Correct.
right? Office bearer organization, he does not.
Right.
Raj Prabhari is a part of the party's.
But yes.
It's not that it's outside the Shiv Sena party
Give me
structure.
the structure.
Then it has, more importantly, when we see a party, it's not office bearers. It's the primary member.
Correct.
Primary member, 4,48,000.
Correct.
So how can in this situation, when you have a hierarchy,
You're right.
and in a hierarchy there is a overlap
Right.
with, or rather a subset of
Right.
the legislative party,
Right.
a fissure develops in the legislative party and proceeds into the primary membership.
All right. Yes.
In this situation,
How should you look at it?
it will be required by the commission to see
Right.
whether this will constitute a
All right. Well,
rival group for the symbol.
I've taken your point. Let me respond to it. Whereas when the split,
This will be
just
let's say you set aside the symbol order.
no, Manas,
They say that, okay, today you go for an organization election.
Manas, we'll come to that symbol later. No, not even on that. At the moment, Manas, I'm dealing with what the Election Commission has done. But apropos what your lordship put to me, let me answer.
Why, Mr. Sibal, we need to decide these questions not purely as legal issues. We have to see the ground reality.
I agree.
Working of the political party, as you rightly indicated yesterday, when the section 28A says that they will follow the ideals of democracy, socialism, and secularism, etc. Today, it is the ideals in the constitution and the administration of the state
Sure, Manas.
and the society.
Sure.
So they cannot have a slogan of secession because it goes against the security of the
Right,
state and the sovereignty of the
Right.
state. They cannot have a party which
Right.
says, we will tomorrow elected make India an autocracy.
Yes.
We will do away with democracy.
Right.
So that is the ideals that he has to hold.
Correct.
And that cannot be completely reflected to have an complete democracy in the structure. There should be semblance of representativeness, etc.
That's right.
This point is well taken.
Yes.
Similarly, when you see a split or a rival group, it's an evolving question.
Yes.
It's an evolving question.
No, I
As
agree.
you said, look at the Samajwadi Party case. If we saw the Samajwadi Party case in 2012, 13, 14, big split. By 18, 19, the split there is no split again. There is a merger. So in this situation, the commission would have taken into consideration the existence of the rival group percolating into the party membership.
That also he didn't do.
That is one thing. That is correct. That is something whether we can supply this reason when that reason was not there.
That's right. No, Manas,
Mohinder Singh Gill principle.
yes, a point.
You cannot. But the thing is, a material which is relevant in support of a conclusion if not disputed, it can be a good reason to sustain, even if that is not.
No, but in any case, he says, I won't look at the organization because I'm only looking at the legislative.
It is the next question.
That's right. No, but forget that. Let me answer your lordship's question.
Rival group, perhaps the commission reasoning requires review.
Yes. But let's leave that out.
Totality of facts, it would be very difficult to ignore the fact that the group which actually may be born in the legislative halls did not have a resonance in the parties.
I will more or less take your lordship's observations to be the starting point of the law, but let me answer it. Your lordship said to me, as I understand, there may be a split in the legislative wing, but you can't just look at that. You have to look at the ground reality as it evolves. Right? And by the time when the petition is filed before the commission on 19th July,
there is a great support to that.
Right. Let me assume that. Now, Malas, what are the facts? Just note one fact. Shivnath Shinde becomes the chief minister on 30th of June. Right? No, let's not forget that fact. On the basis of the legislative strength alone, without reference to the party, he is made the chief minister. What will happen? If you are looking at ground realities, what will happen?
That is why Subhas Desai says that those were all.
Yeah, but what happens when you become a chief minister? Naturally people will come to you. So you mustn't also forget that ground reality.
That inflow of primary members or other office bearers was only by virtue of the office.
That's right, because he became the chief minister. You illegally appoint him as chief minister. Then you say, no, now so many people have come. Now look at our strength. So that's the other ground reality.
If all these factors, then you may not be right in saying the commission jurisdiction at the threshold itself is not there. Approach may be wrong. If the commission doesn't have a threshold jurisdiction, then no question can be gone in.
I agree.
Okay?
That's my submission.
If the jurisdiction is there and that jurisdiction is erroneously exercised, approach is contrary to the settled principle, then it's a different issue. But you want to argue that commission doesn't have jurisdiction at all.
No. I say on the date when the commission exercises its powers under para 15, there should be a split in the party. On 19th July, what does he say? He goes only two documents. Well, kindly just look at, he only has two documents on record.
Right.
One is the legislative strength, and two is a meeting held. Now just look at that.
On facts of this case.
I'm talking about this case.
No, this is on facts of this case.
Yeah.
We are on the general principle of competence and jurisdiction of the commission. That on the date, as you rightly say, on the date when question of 15 arises,
Yes.
the commission will have to examine whether there is a split in party.
That's correct. That's all.
And when you examine this question,
Yes.
it is obvious that all collateral issues will also be gone in.
Correct. So, Malas, whatever for example, I'll give you a lecture. On that day, he said, I'm sorry.
People, we are saying this is, come to paragraph 6 of the commission's order.
Yeah.
On 8/8/2022, the commission received documents from Sri Chirag Shah, learned counsel for petitioner, whereby it is.
That's after 19th July, Malas.
On 22nd, in compliance with the commission direction, letter dated 22/7/22, he files documents.
8th August.
Application petitioner internally has submitted affidavits supporting 12 out of 19.
That's 8th August, Malas.
40 MLAs and further submitted a chart showing support for the petitioner in the organizational.
I don't dispute. That's 8th of August. Malas, please, let's be clear on some basic facts.
This is the question we are putting to you. Will it not, when the commission decides on the symbol, is the time frame struck on the date of the application?
No.
Or the evolving subsequent events which take place?
No. If there is a prima facie split in the party, evolving events will take over. There's no issue on that, Malas. What my lord is putting to me is absolutely right. If the prima facie case is made out, that there is a split in the party, they will evolve. And at the time of the decision, Malas, a decision will be taken as to who is entitled to the symbol. I am not on that stage, Malas. Of course, on 8th August, thereafter, there will be documents filed. But what was the document available with the commission on the 19th of July? Do you need a split on 19th July, Mullah? Let's be clear on that. What are the documents? I'll show you. One is the legislative, Mullah, and what is the other document? Only one other. 18th July. It's very interesting.
They are filing the application on 18th of July.
19th.
19th.
And they show a document of 18th July and the majority members of the legislature. Correct? Now see the,
You have already argued.
no, see 18th July.
Huh.
398. This is very interesting
This one.
of this volume. Yeah. That's what will determine, but that's nothing else. And I agree with my Lord the Chief Justice.
Justice Banerjee was thinking it can be shown later during the proceedings.
No. That cannot be. Myself, Mullah, can a split happen afterwards? Or will it happen on the date when he files the petition under paragraph 15? It's a question that your lordships might like to consider.
So that we understood your argument.
So if the split happens on that day, you have to look at that day. Is there, what is the evidence?
The argument is there must be some semblance
Yes,
of support beyond the legislative party
correct.
to this split
Yeah,
at the time when he applies for the seat.
that's all.
Then he can add on fact.
Yeah, no problem.
This is your argument.
This is my, and Mullah, kindly see, what is that document? I'm
The
sorry.
split is to be seen on the cutoff date of 15.
That's right. Now, Mullah, if you look at that, he has only legislative party, the rest is one document, just see that. That document, even the commission doesn't take it into account. What is that document? Translation of minutes of the Shiv Sena Pratinidhi Sabha. The Mullahs, who are the people present here? Page 297 people. This is the Pratinidhi Sabha, which has all those hundreds and of members. No notice to anybody. He gives this document. So could the commission have come to the conclusion, and on this day, was there a split in the party? But I take your lordship's point. If prima facie the slippage there, it's an evolving situation. And then, Mullahs, whoever ultimately has a larger strength both in the organizational structure and the
That is the
legislature.
same situation which you argued in the Samajwadi case.
That's right.
The argument against Mr. Akhilesh Yadav was that his organization, he had called us organizational sabha,
Convention, yes,
convention,
yes,
which correctly understood by the commission was evidence of split outside the halls of the
on that day,
Legislative Assembly.
yes,
And there the argument against that was it was not as per the party constitution.
yes, yes,
And the decision was we are not looking into the legality of
exactly,
convention, but
exactly,
the factum of support.
correct. And here is none.
Of support was there.
Here was none. Here it is none.
Apply that ratio, then Pratinidhi Sabha, whether notice was given or not, if that document is genuine, there
It is
was
not
a-
genuine. Even just see, look at the document, you see for yourself, Mullahs. If your judicial mind, Mullahs, and the kind of mind that your lordships have, will come to the
We understand, and you have a very strong compelling cases because that document has not been considered by the
commission
tribunal,
itself.
by the commission.
Itself. Because it's ex facie, it's something that.
View whether we can look into that document.
So whether we are left only with the legislative party, then how will para 15 jurisdiction be exercised? So, Mullahs, but your lordship is right. Once prima facie, of course, there's a split will.
It can evolve. It
No
can
doubt
evolve.
about it. I agree. I mean, I have no dispute on that proposition. We have had several petitions which I myself argued both in the commission and here that evolving situations.
Take a pragmatic view here.
Yes, it's correct.
We are dealing with
Correct.
living democratic
Absolutely.
aspirations. We cannot.
I don't know how democratic it is, but we are certainly living in
Everything.
aspirational India. Malad.
Everything is flawed.
Living in aspirational India. So, Malad, anyway, so do have a look, Malad. I would suggest you have a look at this document. 398.
Even
398. Same volume, Malad, same volume.
that is a purported meeting of the Pratinidhis.
Yes, Malad. Kindly see. Translation of the minutes of the Pratinidhi Sabha, 18th July. So 1 day before. And Paksh Pramukh Uddhav Thackeray was absent. Shiv Sena leader Eknath Shinde invited to see the chair. Resolution passed, proposed by
Dissolves the
Dis-
Rashtriya कार्यक्रम.
dissolves the Rashtriya Karyakarani, is dissolved with immediate effect. And unanimously, and then it's proposed by so-and-so. Then further resolved unanimously that Eknath Shinde is appointed as chairman of the new Rashtriya Karyakarani. Chairman Rashtriya Karyakarani will now be called Mukhya Neta. All the powers and duties of party president will now be held and executed by the chairman of Rashtriya Karyakarani, as known as Mukhya Neta. Proposed by so-and-so this thing. And resolution 3, these are common people. And that's it. This is the Pratinidhi Sabha.
It is leaders now, only 2.
And look at the leaders, only 2.
Resolution 3.
Resolution 3, only 2 leaders.
Resolution 4, 7 deputy leaders.
7 deputy leaders. This is it. So if this, Malads, amounts to a split in the party, so be it, Malads.
This will be a good argument on the test of majority. Test of majority premise.
No, but
Even if you hold it to be having convened,
correct.
the test of majority will be in your favor.
No, but then you're left only with the legislative wing, Malads. Then how does 15 come in? This is the problem, Malads. So you have to pass the threshold. If you pass the threshold, test of majority. If you don't pass the threshold, you can't assume jurisdiction. But that prima facie finding will have to be given by somebody. And the election commission itself doesn't refer to this document. Now I go back to the judgment, Malads, so that we now know the facts, Malads, completely. So we'll be,
Page 1.
yeah, okay.
9.
Yeah, okay. So he says that this is undemocratic. That's para 91. Then, Malads, he refers to Ambedkar's speech. Let's leave that, Malads. We don't have to go there. And then he goes to Malads, para 93. And he says section 29A, this is page 502, which deals with registration of political parties, was inserted by Representation People's Amendment Act 1989. And the statements on objects and reasons appended to the bill, which was subsequently passed by Parliament, stated as follows: at present, there is no statutory definition of political party in the election law. The recognition of a political party and the allotment of symbols for each party are presently regulated under the Symbols Order of 68. It is felt that the Commission should define political party and lay down procedure for its registration. It is also felt that political parties should be required to include a specific provision in the memorandum and rules and regulations governing their function, that they would fully be committed to and abide by the principles of the preamble of the Constitution. Then whereas 94, in the present case, the Constitution of Shiv Sena, as amended in 2018, gives unbridged powers to the Shiv Sena Paksh Pramukh. Further, in the final written submissions submitted by respondent himself on 30th of January, it has been stated that under the scheme of the party, the Shiv Sena Paksh Pramukh exercises overarching control in matters of admission and removal of members in the highest authority within the party. Shiv Sena Paksh Pramukh and Shiv Sena party are two sides of the same coin and never be separated. This assertion of the respondent significantly buttresses the petitioner's position in the amendment to the amendment to the Constitution in 2018, being a colorable exercise to give unbridled powers to the respondent and to stifle dissent. Thus, the petitioner claims that both in its design and its working, a backsliding from 1999 Constitution is manifest. The above facts give traction to our previously noted concerns of the surreptitious nature in terms of non-communication of amendment, and equally important, the process of amendment in the Constitution of the party not being in accordance with the conditions as communicated by the Election Commission by letter dated 1989. But how did the 1989 letter come in?
2023.
In 2023, Malad. To Shiv Sena inter alia, stipulating in para 2 the statutory requirements under 29A. Further, this is not in sync with clause 18 and 22 of the guidelines prescribed by the Election Commission in exercise of powers under Article 324. I've shown you those guidelines of 2010, Malad. In view of the aforesaid fact, the test of party constitution will not come to the aid of this commission in deciding the present case. That's how he discards it. So party constitution out of the way, split assumed because of the legislative majority in the Maharashtra Assembly. And on that basis, he says, but since it's autocratic, I'm not going to deal with it. And then he comes to organizational structure.
Show the next line here.
Then next, the commission is of the considered view that the only test to be applied in determining the present dispute is the test of majority, which also he discards in the organization. So he discards it. Now, Malas, he comes to the main issue. Which group faction is entitled to use the symbol bow and arrow? After determining the test to be applied for deciding the present dispute case, it is to be examined as to which group enjoys the majority with respect to support in the legislative and organizational wing. While there is no legal sequencing, we begin by examining the support enjoyed by both groups in the organizational wing of the party. The organizational wing, as noted by both sides, originates in the totality of party members. Therefore, for the test, a filter has been invoked by the Commission previously to achieve a cutoff to determine at what level of the party organization the test should run, and thus the issue as to which of the bodies in the organizational structure of Shiv Sena are to be considered as the organizational wings for adjudication of the present dispute. While the petitioner in his petition dated 1907 has mentioned the support enjoyed by him in the organizational wing of the party, he has simultaneously argued that the constitutional design, in effect, puts all powers in the hands of the respondent, who then amended the constitution in 2018, and thus the source of the organizational count is contaminated. So, therefore, he discards it later. First, he says, I'll accept it. Then he says, no, it's contaminated. He can't call it contaminated till he throws out the constitution. Unless he calls the constitution authoritarian, he can't call it contaminated. So he's already done that. Despite the fact that there is no issue before him, that's not part of 15, and despite the fact, Mullah, that I've shown to your lordships, the constitution itself. In the written submissions on 9/12, petitioner, it was submitted that he enjoyed majority support of the organizational wing of the party. To substantiate his submission, the petitioner indicated that more than 12 lakh primary members, 144 Padadhikari of SSPP, 12 Rajya Sabha Prabharis, as well as a large number of district office bearers of Shiv Sena were supporting him. Further, it was mentioned therein that the Pratinidhi Sabha, through a meeting held on 18/7, and the Rashtriya Karani, through the meeting held on 27/7, had resolved in favor of the petitioner. In the final written submission, dated 31/23, it has been stated on behalf of the petitioner that as per the 18th amended constitution enjoys the support of 4 Shiv Sena leaders, 6 Shiv Sena deputy leaders, besides support of 49 Zilla Pramukhs, 87 Vibhag Pramukhs, 40 MLAs, 13 MPs, and thus an overwhelming majority of 199 in the Pratinidhi. This is the evolving support, your lordship. Yes, that's what you're calling it.
Because Vibhag Pramukhs are not part of the Pratinidhi.
Well, we'll come to that later. Let's sort of that. But my lord is saying you can look at subsequent events to find out. No doubt, provided you are able to say that there's a split in the party on 19th of July. And if you want to look at it, look at the organizational wing. We are far ahead in majority. But he discards that because he knows he can't come to the conclusion that it's otherwise. This statement is not reflected in the data. The data is before the commission. This is what he says.
This is a part of the written submission.
Yes, of his. It's not part of the data supplied.
Affidavit is October, which at paragraph 6.
Yes, exactly.
You see, the affidavit file is recorded in paragraph 6 of the order.
Correct. But Mullah, they have given the chart of what their strength is, comparative strength is.
There, the numerical strength does not hold in favor of the petition.
That's correct.
In fact,
He can't, Mullah, if he votes in favor of the petitioner, then he can't give the symbol to him. So he wants to discard it. He wants to discard the entire organizational structure because he says the constitution is contaminated.
87 are not part of that Pratinidhi Sabha. This Vibhag Pramukh is not part of the Pratinidhi Sabha.
Vibhag Pramukh is not even part of the Pratinidhi Sabha. Not even part of it. And as your lordship rightly said, and I agree with you, after 30th of June, when he became chief minister and he was installed in this fashion, then all of these happened. Even people who were with us moved away.
They continue to go.
And they continued to go, Mullah. And we are seeing that even happening nowadays. So if you allow such a law, let's forget this case. If you allow such political events to take place, that a wing of the legislative party splits, calls itself the party, goes to the commission, then Mullah, this is harakiri. This can't be a constitutional principle. Under any constitution, Mullah, which is, to say the least, democratic. How do you allow a legislative party to be sold to a ruling party, install him as chief minister, then say it's an evolving event, then go to the election commission, get the other support? You can throw out any government in this fashion with the strength of factors that your lordship knows and I know. Let not the law mullahs make a mockery of democracy. This is mockery. And if your lordship wants to know, mullahs, forget the law, see the facts, how it happens. He ultimately in the first part says 21st June, 27th June, 1st July. He himself says, mullahs. That I have nobody with me. So, any government, and this is what is happening now, Malas. Which is why I personally filed a petition. Well, it's only for this, because we can't see democracy being withered away like this. Anyway, on behalf of the respondent, a preliminary reply dated 7/10/22 was received, wherein it was stated the respondent enjoyed a majority support in the organizational wing of the party. Relevant extract of the said reply is set out, Mullas. Well, we'll not go into that. Then he goes into written submissions, Mullas, and then he comes to this dispute at page 102, para 102. At page, Mullas, 506. The vital question for this commission is to decide whether to consider one or both of the two aforesaid organizational bodies of Shiv Sena, the Rashtriya Karyakarani and the Pratinidhi Sabha, to be the organizational wing for determining a numerical majority therein, or to consider other bodies mentioned in the party constitution. The commission in Anna DMK has held the commission will look at the relative strength of the two groups in the apex representative body of the organizational structure of the party as provided for in the party constitution. Further, in the case of Sadiq Ali, the Honorable Supreme Court considered the issue of ascertaining the support among the primary members of the party and held that it is no doubt true that the mass of Congress members are in its primary members. There were obvious difficulties in ascertaining who were the primary members because there would, in that event, have been allegations of fictitious and bogus members, and it would have been difficult for the commission to go into those allegations and find the truth within a short span of time. The commission, in deciding that matter under paragraph 15, has to act with a certain measure of promptitude, and it has to see that the inquiry does not get bogged down in a quagmire. This apart, there was practical difficulty in ascertaining the wishes of these members. The commission for this purpose could obviously be not expected to take referendum of all the towns and villages in the country in which there were primary members of the Congress. It can, in our opinion, be legitimately considered that the members of the AICC and the delegates reflected by and large the views of the primary members. Thus, the commission has to look into the majority support employed by the rival factions in the apex representative body of the party as provided in the party constitution. In order to do so, the commission looked at the party constitution of 2018, cited by both the groups. Now, he relies upon it. Then Article 8, Mullahs. I have already told your lordships, why should I repeat that, Mullahs? Karyakarani, then the Pratinidhi Sabha, I have shown that to your lordships, Mullahs. Now kindly come to 105. A perusal of the composition of the Pratinidhi Sabha shows that it is largely an appointed body. The 2018 constitution in Article 11 of the party provides that the Shiv Sena Paksh Pramukh has the power to appoint Sanghatak, Samanvaya, Rajya, Sampark Pramukhs, Zilla Sampark Pramukhs, Rajya Pramukhs, and Zilla Pramukhs, as well as to co-opt any member as leader and 33 deputy leaders of Shiv Sena. Thus, this body of the Shiv Sena ex facie does not pose confidence of truly being democratic. Hence, any creation of this body can also not be relied upon for adjudicating a dispute under para 15 of the symbols order of the party, Article 11B of the 18 Constitution states that the Rashtriya Karyakarani shall be elected by the Pratinidhi Sabha. Thus, the Rashtriya Karyakarani is a body which is in fact elected by a largely appointed Pratinidhi Sabha. To sum up the situation, it is apt to quote the observation of the commission communicated to Shiv Sena to the chief electoral officer. To put it in a nutshell, party constitution envisages the president nominating the electoral college, that is to elect him. This goes against the spirit of democracy and negates the very purpose for which the entire exercise was carried out. And then Balatsi relies upon T.N. Sessions' judgment in dispute number 1 of 1994, which I would like to read to your lordship. So, Maharaj, this is what, as I told your lordships earlier, he says Pratinidhi Sabha includes all these appointed people. So anything done by them, any election by them is meaningless because they were appointed. And therefore, Sindhe was also appointed by them, it's all meaningless. Well, this happens in any political party you will see. Now let's see
It actually says.
what the learned judge quotes is not what the judgment says. The Commission has observed in its order of 25/178 in the case of dispute in the INC that a group or section which wants to form a rival group or section within a party must exhaust all the remedies available to it under the Constitution of the party to assert its majority and should come to the Commission if the other group has frustrated its efforts whimsically or capriciously and not in accordance with the party constitution or democratic norms. In almost all the cases of disputes in political parties which I had the occasion to deal, this is Session writing with us, allegations have been made that the disputes had arisen or splits occasioned due to the arbitrary or capricious exercise acts of certain office bearers who were not allowing the will of the majority to prevail. But in all such cases, what the Commission was confronted with was some office bearers occupying or sticking to their offices by the manipulative tactics of postponing or not holding altogether the organizational elections in the party, and with some ad hoc committees or bodies constituted of some handful of nominated members chosen at the whim and fancy of the leader at the top. The test of majority in such ad hoc nominated bodies also becomes redundant. Firstly, such ad hoc nominated bodies, having been formed by the party bosses themselves, will naturally consist of the favored persons who will rarely go against the wishes of those to whom they owe their very existence in those bodies. In the next place, such nominated members cannot be truly termed the representatives of the primary members who had no say or hand in their appointments, and consequently, the decisions taken by such ad hoc nominated bodies, even if by majority, cannot be regarded as the decisions reflecting the wishes and aspirations of the majority of primary members. Confronted with such a situation, the Commission finds itself in a helpless situation to grant relief to those who approach it seeking protection against the tyranny of the privileged few who have been treating the political parties headed by them as their fiefdom. This emerges, Malaj, from a dispute that happened in the Janta Dal, where Malaj, George Fernandez files a petition. And on the other side is S.R. Bomai. And Malaj, George Fernandez says that no meetings have been held under the Constitution for years. For years. And no body has been set up for years. Everything has been happening ad hoc for years. That is how the issue arose. It's completely irrelevant for our facts. There is no complaint here, Malaj. He abides by the Constitution. He is nominated by the Raj Pramukh. He has never raised an objection. There is no issue within the party. And our bodies are all as per the Constitution. And in that resolution, he, Malaj, in fact, gives to himself the powers greater than the Paksh Pramukh, Malaj. He says, I am the Mukhya Neta, and I have now dissolved the Karyakarani, and I am everybody. This is what the new constitution that he sets up. And then he complains about being undemocratic. Who prevents him not from moving out? But he had other sort of avenues in mind, which brought him to where he is.